Good evening, everyone, and welcome to this evening's webinar, which is on the duty of candour. My name is Michael Devlin, and I'm Head of Professional Standards and Liaison here at the MDU. And I'm delighted to introduce to you the other people who are alongside me this evening in a virtual sense. From my colleagues and our liaison manager department, we have Carolyn Porton and two senior colleagues from my who are colleagues in the advisory department here at the MDU, Dr Ed Farnan and Dr Gerard Ross. But Carolyn's going to initially say a few words about the educational offerings here at the MDU. Carolyn.
Thanks, Mike. I'm just going to take a moment or two just to let you know that I'm one of the liaison managers at the MDU, and part of our role is to deliver educational seminars to doctors, and that's across all fields. So we have a team that work with the students that can come into hospitals, and I'm actually one of the GP team where we can come into GP practices and provide educational learning for you and your team. So we were able to do a number of courses, a number of lectures, one of which is this one on the duty of candour. You can see in the first column on the slide a couple of other options available, so we can talk to you about record keeping, things like medication errors, challenging patients. These are all available and they're all free for you to access. So this is where a liaison manager can come into your practice or your hospital and deliver some training face-to-face in the team. And we also do it online, so if you find that that's the way you're working at the moment, very happy to set up that for you. So it's a good chance to talk with your peers, look at real life scenarios and have some good discourse about these difficult and interesting topics. So that's something that our team does. There are also other educational resources that you can get through the MDU. We have other courses that are available. You can see an example of some of the dates there. We do further webinars which we advertise, and we have a host of e-learning that's on the website, and all of that is free. So I think one of my colleagues is putting into the chat the links that get you access to all of these resources. So please do take a look. There's lots there for you to benefit from. So if you want to find out a bit more, particularly if you want to contact one of the liaison managers, you can see on the slide, it's very easy. There's a link that you can go to there. You just find out who we are, and then we will come directly to you, contact you, and find a way to set up whatever education you like to take forward in your practice. So I hope that's helpful to you, and I'm going to hand you back to Mike.
Carolyn, thank you very much indeed. And thank you all for joining. And what I will do now is we'll start the presentation. And if I can just begin though with a few housekeeping points. You will get a certificate of attendance, and that should reach you later in the week. You will also see on the control panel when you join, there's a little question mark to the side of it. If you click on that, that gives you the opportunity to ask questions. And what we intend to do is take those at the end of the presentation. If you can try and keep them as short as you possibly can, it just means we can then get through more. So please use that function. Also, there are about 5 poll questions that we'll be asking as we go along. So please, when those pop up, if you can answer them as soon as you can, and then we'll feed back those as a sort of live part of the discussion. But without further ado, let me start to tell you a little bit about duty of candour, and in particular, the points we think you might need to know about and that you might find useful and practical. So this is a summary of what we'll be covering. So it's going to be talking about mainly the professional duty of candour, but we will of course talk about the statutory duty in much more detail. And in particular, we're going to look at the practical aspects of that when the duty is engaged, i.e. when you must tell patients about something that's gone wrong. Part of it will also be talking about apologies. What is it that makes an effective apology? And towards the end of the presentation, there's a few slides just looking at what research has been done, what we know about the duty of candour, how effective it's been, and so forth. and also about developments in Northern Ireland, which hopefully you will find of interest, even if you're watching it from a different part of the UK. And if I can also just flag up that the presentation is going to concentrate mainly on England. And the reason for that is because although the statutory duty of candour is already established in Scotland and is going to come into Wales next year and possibly Northern Ireland later this year, there is a lot of overlap, and to do justice to all four parts of the UK would be quite so lengthy. So we're just concentrating on England, but please don't read anything into that. Certainly no disrespect meant to any other parts of the UK. So the background to the duty of candour and the statutory duty of candour in particular goes back to the Mid-Staffs inquiry. And you will probably recall Sir Robert Francis in his report was severely critical, not only about what happened, but the fact that when it did happen, patients and their relatives weren't told. He described this culture of covering things up and not being open and honest with patients. And as a result of that, one of his recommendations was that there should be a statutory duty of candour, which should complement the professional duty of candour, which we'll come on to in a moment. And you'll learn a little bit more about these two types and how they overlap, but it's just to say that was in 2013. Then by 2014, the statutory duty was introduced for trusts in England, and then in 2015 for all other organisations that are registered with the CQC. And this is just a very brief summary slide. I did say that it was already established in Scotland, as you will see, since 2018, and it's coming into Wales and Northern Ireland. But I don't intend to dwell on it too long, apart from to flag up that if you're not in England and you're not quite sure what to do call our advisory team, and they can always guide you through what the process is in your particular part of UK. But if you are in England or Scotland, then this is already with you, and it's something you're probably aware of, even if you're not necessarily familiar with all the details. Why is it important? Well, there's a few points I think to take on board here. First of all, it is about the relationship with your patients, that mutual relationship of trust and respect. It also helps to promote what we all want to happen when things go wrong, and that's to learn the lessons and try not to repeat them. And one of the points here, it encourages comprehensive documentation and recording of patient safety incidents. That might not seem terribly important, but of course it is part of the culture of capturing things in a really effective way. And the last point, which I think is important, is that the statutory duty of candour is entirely consistent with doctors' ethical obligations. This is nothing new. Duty of candour has been around for an awful long time, and we as an organisation have been encouraging doctors to be open and honest when things go wrong. What does the GMC say? Well, it is absolutely clear. It uses the word must, and uses the word must quite carefully in its guidance. And that applies anytime there is an obligation to do something. So it says you must be open and honest with patients when something causes or has the potential to cause harm or distress. So you can see that's quite a broad parameter in terms of when it might apply. It then goes on to explain what you should do. So you must, and that word is there again, tell the patient or their relative when something has gone wrong, apologise, try and put matters right if that's possible. It won't always be the case, and also explain the long and short-term effects of what happened. This diagram, I think, is helpful just to understand how the two duties overlap and relate. I like to think of the statutory duty of candour as being a subgroup of the ethical professional duty of candour. So the ethical duty applies to pretty much every circumstance where something has gone wrong and the patient suffers harm or distress. The statutory duty of candour, as we will learn, applies in slightly more defined circumstances, but essentially, any time the statutory duty of candour applies, the ethical duty of candour will also be applicable. You can see that there is GMC guidance that relates to the ethical professional duty. And on the right-hand side of your screen, you'll see the relevant regulations that apply to the various bodies that are registered with CQC. So that's hospitals, GPs, and indeed private practice. I just want to touch on apologies, and the important thing to emphasize, and I suppose if there's one point that I'd really like you to take home this evening, it's this one. An apology simply does not imply guilt. Guilt cannot be inferred from you saying sorry to the patient for something that's gone wrong. The NHS resolution, which, as you may know, helps to deal with claims against NHS trusts, foundation trusts, and now GPs in England, produced some guidance that was really helpful in 2019. So apologising, they say, is always the right thing to do. And I've racked my brains to think about circumstances where it wouldn't be appropriate to apologise to patients when something has gone wrong. And I've never, ever been able to think of an example where you shouldn't do it. So it is, and I agree with them, always the right thing to do. As we've said, it's not an admission of liability, but it does acknowledge to the patient or their relatives that something went wrong and it could have gone better. And also, taking you back to a couple of slides ago, it is part of the learning process. And by learning, you hopefully prevent future recurrences. What is an effective apology? Well, this is not a set of hard and fast rules, but it is our experience, if you like, of best practice. On a practical level, what will work in our experience? First thing is try and do it face to face. Over the telephone, it's never going to be quite as effective. Also, speak naturally to the patient as you would in an ordinary conversation. Don't be legalistic, don't use jargon, don't try and hide behind weasel words, that type of thing. If you're genuinely sorry, say so, and don't be afraid to say so. It's also helpful just to not treat an apology as something in isolation. So set the scene, give the context, explain what happens. And of course, once there is context, then the apology will probably more naturally follow from that. Also, just to emphasize, a meaningful apology is a process, it's a dialogue. It's not a one-off event, and sometimes you may need to come back to it and reiterate it at a later date with the patient. Don't worry about apologizing more than once. It may well be appropriate to do so. And the final practical point is think about privacy and body language. So by privacy, it's probably going to be less effective if you decide you're going to do this on a busy ward round with the bed surrounded by loads and loads of people, and the patient probably won't appreciate it if that's done. And in terms of body language, open body language, and I realize I'm speaking to an audience of experts in communication here, so you don't need to for me to sort of tell you what that means, but certainly we have found that where communication is really good, then an apology tends to land much, much better. So the first of our poll questions, and it is simply this: are you aware of the statutory duty of candour? So if you would like now just to answer that question, if you can, and we'll give that a few moments. And I'll give you just a few more seconds but I think we're beginning to see a pattern now. So just over half, so the majority know a little bit about it. About a third say they're very familiar with the statutory duty of candour, and a small number weren't really much aware of it beforehand, which is absolutely fine. And of course, this is entirely the point of tonight's webinar, to give you a bit more background information so you're more comfortable in what your obligations are and what to do. Now going on to the statutory duty of candour, and just to set out what the principles are. And the first really important point to emphasise in England is that it applies to organisations, not to individuals. We've talked about apologies and how important they are, and indeed this is reinforced in statute. So the organisational statutory duty also requires apologies to be given. But as we've said, they are important anyway, and they will help resolve issues. Now, the thresholds of when it applies, and we're going to come back to this, are really quite complicated. And I won't say much more about it at this stage, apart from saying that it's essentially moderate or severe harm or death. Now, the assessment of threshold is also done by a healthcare professional who's been independent of the incident in question. And the final point there is that staff must be offered support. Now, that will obviously depend on the incident. So if there's something catastrophic that's gone wrong, you will very often find that staff are themselves traumatized by it. So the need to offer them support is a vital part of this. And of course, it's all part about promoting that learning and just culture. So another poll question, sorry, these are coming thick and fast at the moment. Have you ever felt that you couldn't be open with a patient if something went wrong? So we'll leave the poll open for a few minutes, for a few seconds, I should say. I'll just wait until we get either a clear direction of travel or a critical mass of people who voted. Okay, that's fine. Yeah, we are getting, I think, pretty much an even split. Slightly more people have said that occasionally they couldn't be open with patients if something went wrong, but 44% said no, never. And a small number, 3% of our poll said yes and often. And I think those sentiments are something that we do find when we go and talk to people. So very much your sense is reflected in what we find. Now, I've emphasised the fact that the duty of candour, the statutory duty of candour, applies to organisations. That doesn't mean to say that individuals within the trust or in general practice aren't important to make sure it works effectively. And the most important point, in my view, is the second one along on the arrow there, and that's to understand your organisation's procedures. So understand them, know how you report something, and make sure that you do so as promptly as possible. You may well find, if you're a senior clinician, that you're fairly routinely involved in discussions with patients when things go wrong. And indeed, you might be the person who's asked to take part in a meeting. The final box along the right there is something I'll just come back to a little bit later in the presentation, but just to remind you that this, if you like, is policed by both the CQC for the organisation, but also the GMC. So a failure to act with candour is something that you certainly don't want to happen, and it could result in a complaint to the GMC. Now, I've mentioned that the statutory duty applies to organisations. What I haven't emphasised as yet is that this is part of a general duty to be open and transparent when things go wrong. And as part of the general duty, there are specifics that have to happen as well. So this is a list, and some of this is repetitive, such as mention of apology here. But I think it's important because it does emphasize how important that is as part of the process. So as you can see, there's a need to tell the patient as soon as something called a notifiable patient safety incident occurs. Don't worry, we're going to come back and tell you what that means. Give the patient as full an explanation as you can when you go and speak to them. Provide that apology, keep a written record of your notification to the patient, and also offer and provide reasonable support to the patient. When things go wrong, often they're frightened, shocked, and they're really worried about what the future might hold for them. So they might need more support. And just to be aware of that the regulations require that of the organisation. So I mentioned we would come back to what a notifiable patient safety incident is, and it is as follows. It's any unintended or unexpected incident that occurred in respect of a patient during the provision of a regulated activity, and that is legalese for a patient who's being treated clinically by your organisation. And then that in the reasonable opinion of the healthcare professional appears to have resulted in or could result in certain specified serious incidents, and I will explain a bit more about what those are. So it's got to be unintended or unexpected, and it's got to have occurred during the provision of clinical care. So someone who perhaps trips on a loose stone on the way into the hospital, it wouldn't apply, but it will if it's occurred during or immediately after treatment. Now, we've talked about thresholds, and I touched on that on an earlier slide, and you'll remember moderate, severe harm and death were the principal times that it would apply or be triggered. There's also prolonged psychological harm, which means psychological harm that lasts for 28 days or more, prolonged pain, again 28 days or more, but it doesn't apply, and I do want to emphasize this, to no harm or low harm or near miss incidents. It's been specifically designed that it's triggered by the more severe patient safety incidents rather than the commoner ones. And what that means is that it'll be triggered slightly less often than, for example, the professional duty of candour would, because the professional duty of candour would apply in low harm incidents. And indeed, you may well feel that you want to tell this of patients about other incidents, even if there was no sort of harm, particularly if there's a could have been, and the patient may find out about it much better that they're told by you. So a poll question here, in fact, there's two for the price of one with this one. So the first part of it is, have you been involved in a notifiable patient safety incident, which triggers compliance with the statutory duty? And if your answer to that is yes, how did you respond, if you can recall, to the patient or their representative? So again, I will give you a few moments to look at that. So with the first part of that, we're getting quite a clear consensus. I think roughly 2/3 of you haven't, and 1/3 have. So now the second part of that, if yes, how did you respond to the patient or their representative? And again, there's a few choices here, so do please take some time, have us a read and see which best fits your experience. So again, I'll give you a few more seconds just to have a look. And as might be expected, because a lot of people haven't been involved in the process, therefore that's what we're seeing. But of those who were, certainly a big proportion of those, 25%, apologised, 18% provided an explanation, and 7% explained how things could be put right. So I think that's really good, and you know, from my perspective, you've done a really good job in complying not only with your professional duty but indeed with the statutory duty. So moving on to the next slide, and we're just now going to talk about thresholds. And I've told you what those are, but I haven't really explained what things like severe and moderate harm mean. So I will read this out because hopefully it'll give a very strong sense of how bad it has to be to meet the severe harm threshold. So it's a permanent lessening of bodily, sensory, motor, physiologic, or intellectual functions, including removal of the wrong limb, for example, or organ or brain damage that's directly related to the incident and not related to the natural course of the illness. So you can see how that would apply to the most severe types of harm. Moderate harm, this is, again, perhaps not the most clear definition, but it's the one that unfortunately we have to live with. So it's harm that requires moderate increase in treatment, and it's significant but not permanent harm. So it goes on to give explanations. So moderate increase in treatment could include an unplanned return to surgery or an unplanned readmission. And there could also be a prolonged episode of care, such as extra time in hospital or as an outpatient, cancelling treatments and so forth. Now, the guidance by the CQC, which is where you might want to go to just to find out more about the statutory duty, should you wish, was updated in May of last year. One of the bits that they emphasised in that update was that in the second part of that, the moderate increase in treatment, where it talks about an unplanned return to surgery or an unplanned readmission, that doesn't mean that any unplanned return to surgery is necessarily moderate harm. It has to be associated with significant but not permanent harm. So just to emphasize that, because it is something that was updated by the CQC in its guidance last year. So we're now going to go on to a few examples, and although these won't be poll questions, what you might want to do is have a read. I will read through them, and whilst we're sort of doing that, have a think what you would answer as to whether the duty applies in that particular scenario or not. So the first, the patient has an excision of a basal cell carcinoma. They develop wound infection requiring 10 days of antibiotics only. So do you think that is a yes or a no? Well, we think it could be either. My view is that where there is any doubt at all, treat it as a yes. You can't do any harm by taking the cautious route, but it could be argued either way. The second scenario is the patient's told by a doctor that a lung lesion on X-ray is likely to be cancer. An MR scan ultimately shows that to be an artifact, and on review, the patient says that he's been really stressed for the last 5 weeks. So could that trigger it? What do you think? And we think the answer to that is probably yes. So it is the prolonged psychological harm gets past the post as far as that goes. And the next example, following a fall, a patient has a wrist fracture, reduced and immobilized in casualty. After the cast is removed, it's noted that the reduction wasn't very successful and there's appreciable residual dorsal displacement. So perhaps we're getting onto slightly easier territory here, but what do you think about that? And indeed, the answer there is yes. And as you can see, there probably is permanent and significant harm there because of the poor outcome. So just some more examples. And the same thing, I'll just read it out. You have a ponder as to what you might answer, and then we'll see whether your answer is the same as ours. So after an emergency cesarean section, a patient required a blood transfusion. Midwife noticed just before putting up the blood that the group didn't match the notes. It wasn't given, and it transpired that the sample had been inadvertently switched with another patient. There were no ill effects to the patient, but plainly it could have been very serious and the patient could have died. So what do you think about that one? And that would be one that doesn't trigger the duty of candour, the statutory duty of candour, because of course it was a near miss rather than something that actually happened and did cause harm. So the next example, following a steroid injection into her knee, a patient developed a continuous sharp burning pain immediately, the same side that the injection was given. 10 days after that, a rheumatologist concluded that the injection had damaged the saphenous nerve, and probably because the anatomy being difficult to identify due to the patient's obesity, and the pain was thought likely to become chronic. So your thoughts about that? And our thoughts are that yes, it would meet the threshold in our view, and that's an example of the prolonged pain. So pain likely to continue for more than 28 days. Some more examples, and this is a patient who's inadvertently given unopposed estrogen for menopausal symptoms. It resulted in postmenopausal bleeding, and that required referral, further investigation. The patient became increasingly tearful, saying that she feared the worst. So what do you think about that? Again, we think yes, because that certainly did result in additional treatments that was significant. It did result in harm. The patient was clearly very upset by what had sort of happened. And next example is you're a GP looking after a 71-year-old woman with memory loss, apathy, and you've diagnosed her as having dementia. She's treated for several months in the memory service before she's reevaluated and diagnosed with depression, which responds to antidepressant treatment. So again, tricky one this, but your thoughts? Again, we think this would trigger the duty because it is something that has now gone on for several months, probably had quite a significant impact on the woman and possibly those who are close to her as well. So hopefully those scenarios have been quite helpful. But this is a question for you to think about before we go on and explain a little bit more. So the poll question, do known complications trigger the statutory duty of candour, even if discussion of these complications form part of the consent process? So the polling is now open. And yeah, we're getting, I was going to say a very, very clear, yes, we are, I think, getting a very clear steer from our expert audience that yes, it would. 25% think no, and a sort of number of people aren't sure. So again, well done for those that answered yes, because you are absolutely right. It does apply to known complications. And here's a good example. CQC prosecuted a hospital in Plymouth, and that was because a patient had died as a result of a known complication, which was esophageal perforation after endoscopy. But what happened next is that the trust unfortunately failed to follow the process for duty of candour, and the family weren't told about why the complication had arisen, and basically they just weren't candid and open and apologetic. And as you can see, that resulted in quite a significant fine when they were prosecuted by CQC. And okay, only £1,600 of that related to the fine itself, but it's still quite a significant charge to the hospital. And Nigel Aitchison, the Deputy Chief Inspector of Hospitals, reminded people in a statement that all care providers have this duty to be open and transparent with patients and their loved ones, particularly, he said, when something goes wrong. And he said this case sends a clear message that we will not hesitate to take action when that does not happen. To be fair to CQC, taking enforcement action of this type is relatively rare. Most of the time when things don't happen quite as well as they should, they do pick up those situations on inspections, but will prosecute much less frequently. But it just shows those powers are there and they are used. Now we're coming on to the last parts of the presentation. I did say I was going to come back to a few other bits of what I hope are some interesting insights into the statutory duty. And the GMC in 2019, in an answer fact in a submission to a consultation in Northern Ireland, which I'll come on to in a second, provided a breakdown of action it took when it received complaints of duty of candour. Now, it is fairly common for the GMC to take no further action in the majority of complaints, certainly in 60% or so that it receives. And you can see in this case that applied to duty of candour as well. So almost 3/4 were closed with no further action. But you can see a small proportion, but a really important percentage of 11% did actually go to a tribunal. A smaller number were dealt with by undertakings. So that's when the doctor agrees voluntarily to perhaps take more notice of the of the professional duty, it would be in this case, take more notice of the duty and to undertake to follow the rules and the guidance more carefully. 2% a warning and 8% advice. So again, the GMC do see these complaints, and as you can see over that 5-year period, there was 500 or so. And I mentioned that we're going to just have a glance at some research that's been done. What I would say here is that there has been precious little, surprisingly little. One of the bits of research that has been done, though, is by the Professional Standards Authority. And as you may know, the PSA is the body that oversees all the professional regulators, so GMC, GDC for Dentists, General Pharmaceutical Council, and so forth. And in 2019, they looked at how effective candour was, and particularly what the enablers and inhibitors to that were. And they compared it with previous research they carried out 6 years earlier. And as you can see, the inhibitors were fear of litigation, of action by the regulator, and also of the matter going public and getting into the media. So that fear factor certainly puts people off being open and honest when things go wrong. And what things promoted the duty of candour? Well, it's where you have an open and just culture, and perhaps there's no surprise there, and also timely action when something goes wrong. And the third thing I think is quite important, because it did find that where the trusts and organisations invested in good education and training so everyone knew what their role was, it was a much better way of proceeding, and it did result in people being more able to take part in the process and follow it properly. There's also this paper that was a collaboration between Manchester, Birmingham Universities and the Nuffield Trust, published in 2018. And what their research indicated was that there was measurable increases, in their view, in openness of culture since the statutory duty had been implemented. It found that there were net reputational benefits to trusts, and there were increases in patient confidence, i.e. that patients believe that they would be told if things did go wrong. But as you can see, although certainly candour is good for candour's sake, it doesn't seem to have any impact on the bottom line in terms of claims or complaints. But it may well be over time we see that changing, we just don't know. But certainly that initial research says do it, and it does what you hope it might in making patients more confident, but it won't necessarily stop complaints from arising. I mentioned I was going to say a word or two about Northern Ireland, and you may have heard about the hyponatremia inquiry that went on for, I think, well over 10 years and finally reported in 2018 into a small number of deaths relating to the overtransfusion of hyponatremic solution to children. One of the recommendations of Mr. Justice O'Hara, who led that particular inquiry, was that there should be not only a statutory duty of candour on organisations, but he has recommended that there is an individual duty of candour as well. So this would be a first for the UK countries, and it will be the first country, if it is implemented in this way, to have a duty on individuals. But what causes us greater concerns is that his recommendation is that there are criminal sanctions attached to both a breach of that duty or to the obstruction of another in the performance of the duty. And the Department of Health in Northern Ireland that is consulting on this has made it clear that they think it's going to only apply to the most severe cases. But I would just make this point, and obviously on your behalf, we very strongly opposed that suggestion that there should be any criminalisation of the statutory duty of candour. And a really good example are the case of vincristine, where it's inadvertently injected intrathecally rather than intravenously. And as you will recall, there were a number of these deaths over quite a few years. What stopped that happening in this country was when there were very strong systemic measures put in place, including physical ones, to make it almost impossible for that to happen. Doctors were prosecuted, successfully so, but the prosecutions didn't stop anything from happening, but a proper patient safety approach did. So it's the sort of systemic approach is the one that's likely to lead to better patient safety rather than putting doctors in the dock. I mentioned that consultation, which, as you can see, has closed now. We're still waiting the Department of Health's response to that. The soundings that we're getting is that we do think, because the political parties are fairly united on this point, we do think it will be implemented as per the recommendation. So it will be an individual duty as well as an organisational one in Northern Ireland. And we anticipate that, unfortunately, there will be criminal sanctions attached to it. So if you're in Northern Ireland, I'm really sorry that's the case. We would rather have won that argument. We have certainly tried, and we will continue to try to persuade them otherwise. So we're almost finished now, so we'll hopefully have some time at the end for questions. But this is just a summary. Professional duty of candour is there, and we know it's effective because only 11% of GMC complaints, as we saw, were actually referred on to a hearing. But the statutory duty, it is complicated. It has those difficult to understand thresholds. There are procedural processes that must be followed. And the important thing, I think, is to find out what your local arrangements are, make sure you're familiar with those and you know how to follow them. We've seen from the research that fear remains the most potent inhibitor of candour, organisational culture the best enabler. But there is limited research. And finally, there is no evidence that criminalising healthcare reduces harms. And we've got lots of evidence to show that in my view. But unfortunately, it does look like we are stuck with the possibility, at least, that that will be introduced in Northern Ireland. So that is the end of my presentation, and I will stop sharing my screen, and hopefully my other colleagues will now be able to come back and join me on the screen, and we'll be able to take questions. And my colleagues, Gerard and Ed, I know have been keeping an eye on the questions, and thank you very much for putting those forward. And Gerard or Ed, would you like to maybe sort of kick off and give us your thoughts?
Yeah, one of the questions which came up quite a bit early on in the presentation, Mike, but which I think you touched on and I think clarified later, was the issue about things which were discussed as part of the consent process. And it raised a lot of questions initially, and then some further questions after you touched on it about when something is discussed as part of the consent process, can it then engage the duty of candour if that particular complication or side effect comes to pass? And I think just based on the types of questions we're getting, I think the point to clarify there is absolutely yes, it does, but only if it crosses one of those thresholds. So it's not necessarily every complication or minor complications, but if it's a complication which touches one of those moderate or severe harm thresholds, then in that case, that particular complication, even though it was discussed, is likely to cross that threshold and engage the duty.
Yeah, I think that's right. And I suppose the sort of problem is, as we've discussed, it is so complicated that we know that if you're talking about the professional duty, yes, clearly it would. That's straightforward because it's so broad. But at times, working out these thresholds can be complicated. But yes, it would be engaged, but you would have to have that moderate or severe harm. And it's a good point. Thank you.
I think that's the point of involving other people. Some of the questions that have come in have been really quite specific, scenario-based questions around quite specialised areas of care. And I think that's where having another person who understands the care that's being provided, reviewing it, who's not been directly involved in the care provision, it's important. So there's a question about a very specific aspect of cervical smear reporting, which I don't think we could offer an opinion on, but another cytopathologist might be able to offer a view on the relevance of the decision making around it.
Gerard, that's an excellent point. Yeah, no, just to re-emphasise the fact that the process has built in this review by an independent healthcare professional, which is a good safeguard.
There's quite a complicated question, and I'm sorry to give this to you, Mike, but I do think you might be the right person to address this with your various hats on for the MDU. One of our members has raised a concern about the potential overlap between the duty of candour and protected disclosures or whistleblowing. So I asked for a little bit more context on that, and the example given was a situation of a doctor raising some concerns about availability of equipment within a coronary care unit, a patient then going on arresting, something not being available during that arrest, and the patient has died as a result. So they were concerned, and they gave an example of a doctor who, in raising concerns about the issue, in disclosing it as a matter of part of their duty of candour to the family, went on to have significant problems with the employing organisation. I must say that it's not something that I'd come across in frequently, if at all, in all the discussions I've had with our members about duty of candour, but this is obviously a situation which other experienced doctors in other areas have had. Have you come across that problem, Mike?
Well, I have heard those kinds of concerns being sort of raised, and I think actually by coincidence it was Robert Francis, again, who carried out a separate review on speaking up safely several sort of years ago, and I attended a couple of workshops. And it was one of the bits of feedback that people were sort of giving, that they were actually quite afraid to speak up because of what they perceived as the possibility of vindictive action being taken against them by their employer. Now, personally, it wasn't something that I'd seen in my years as a medico-legal advisor, but the fact that people were mentioning it in that type of forum suggests that it is real, and that some people have experienced that. My view strongly is that your ethical obligations trump everything else. So if you see something that requires you to speak out and speak up about it, that's what you must do. And if you ever then face detriment because of that, then we're really lucky because we've got the likes of you and Ed who can then offer advice and support. So don't ever feel that if you then do face the wrath of your employer, that you can't come to us for advice and support, because plainly you sort of can, and that's an important part of what we sort of do.
Okay.
Can I move on to a slightly different topic? And it's one which I know causes concern to our members, and it's simply about the wording of apologies. Now, you touched on that certainly in terms of the protection or the protected status of apologies, but people want to know how to word an apology without incriminating themselves. And I suppose my initial thought on this is that patients are keen to get an apology, and an apology is often the thing that resolves a situation if it's a sincere apology and one which is well worded. I think that there's a tension in some people's mind between getting the apology right, but then incriminating himself, which is what the doctor here was afraid of. Is there anything you can say to reassure the doctor that he's unlikely to incriminate himself with a sincerely made apology?
I can hopefully provide some reassurance, and by incriminating, I am assuming that the implication here is that someone might face a criminal investigation and prosecution for having given an apology in good faith.
Or I suppose the alternative would be that they might leave themselves liable in face of a claim.
Yeah, and I can see that would be some concern. I mean, dealing with the potential criminal liability, we have at the MDU another senior colleague, solicitor called Ian Barker, who's probably one of the most experienced solicitors in medical crime anywhere in sort of UK. And I remember him speaking about this on occasions, and he said, in order to give an apology that would be genuinely culpable, you would have to go to great lengths to make it absolutely clear that you intended to do something, or that when you did something, it was so plainly reckless that you disregarded all other possible options and you ploughed ahead with it. So you would really have to work hard to provide a form of words that was going to land you in difficulty. And certainly when it comes to civil liability, so are you going to say something that could prejudice the defence of a claim? What I think is really helpful there is the guidance saying sorry from NHS resolution. Plainly, they say it's not a problem. The Compensation Act says that a plain and simple apology can be disregarded as far as equating that to an admission of liability. And I don't know what you think, Gerard, but I mean, my experience over the years is exactly the same as Ed's, that where you give an apology promptly, sincerely, heartfelt, that it just helps resolve so many of these issues.
I think that's undoubtedly true. I do understand the concerns around it. I remember, the same situations for me in clinical practice as a surgeon, when something had not gone the way that had been expected, the difficulties around saying sorry around that. It was hard to do. And in fact, what another person has asked specifically about patients misinterpreting an apology for an admission that a mistake was made. And I think it's a similar question, that your apology is for the outcome that has occurred, not for that you having caused specifically the outcome to occur. So I think, again, it's about how you word it.
Yeah, and just to emphasize again, I mean, do please make the most of your MDU membership, because if you are concerned about, for example, things like wording, it's something that we've got a lot of experience in looking at what members draft in terms of their statements. So just to be clear, we never tell you what to say, but we can look at what you have said and just help you present that in the best possible light.
I've got an interesting one. One of the attendees has said that they usually deal with the consequences of something going wrong quite early on in discussion, because that person had actually been at the other end of a medical error as a patient. Not so. She's a doctor who's been involved in a complication, had a complication, and she certainly focused on the consequences of that issue early on, and that's what she focused on in the discussions that she had. So let's carry on, see what else we've got. Do you have one to hand there, Ed? I'm just spinning through the long list trying to find one I can ask.
Well, maybe just to pick up on that point that you raised there, it's important where possible to be as open with patients as early as possible, but you don't always have all the answers. And I think
absolutely, and it can be an ongoing discussion, can't it?
Yeah, say what you know, but don't sort of speculate ahead of events. If you give somebody the wrong information too soon, that can break down that level of trust that you're trying to establish if they subsequently find out that you've said something that was maybe said in good faith or trying to say the right thing, but was the wrong thing at the time.
Somebody's asked a question about an example of an incident by omission rather than commission. You know, when that might engage the duty of candour. And I guess that I was thinking in that context of somebody who's prescribed something that the patient is allergic to and has not taken note of their allergies but gone ahead and prescribed anyway. That might be an omission that might result in the duty of candour being engaged if they were found to be subsequently allergic to that.
I think that's right, and our view would be that it does apply in both circumstances. So if someone suffers harm because of something you did or you failed to do, then yeah, it's going to trigger that sub-duty. Both duties, I hasten to add, both the professional and the statutory one. Just to emphasise that as Ed and Jared are sort of flicking through the questions, there have been a great number of them. So because of us, please don't think that there have been very, very few, but we're very grateful to you for sort of having put so many forward. But they're sort of doing their best editorial skills and picking out the ones that will hopefully be of most interest.
There's an interesting one here, which I think is something which again will chime with the doctors. We've reflected, and you've reflected, that the duty of candour is potentially good for both trusts and for patients, but what about the clinicians? And I think, you know, it comes back to this concept of, to some extent, the second victim, which we talk about, where although it may be the patient who has been harmed, the doctor who has been involved in that often is traumatized by it, because it's the last thing any doctor wants to do is to sort of be in a position where they feel they may have caused harm to a patient. And it's very important that cultures within trusts recognise that and provide support both for the patients but also for the doctors where possible.
I think that's right, Ed. I think the research by the PSA really bears that out, absolutely. The importance of organisational culture, and although you've probably heard a lot about just culture, but it's one of those really elusive concepts, isn't it? We all know what it means. We'd like to see more of it, but like all organisational cultural change, it's actually quite difficult to achieve. So we certainly do sort of call on all the senior leaders within the professional to do their utmost to make sure that their own organisations have that just and learning culture. So do we have time for maybe one more quick question before we draw things to a close this evening?
There's one to do with documentation, and I think that it's often a problem that I see with doctors writing in for assistance on the duty of candour, the actual steps that are required to be taken in fulfilling that duty of candour. And as a few doctors have asked questions about whether they have to let the GP know, whether they need to keep a written record in the medical notes, does it require writing a letter to the patient? So taking those in reverse order, it does require letting the patient know, and you're going to do it in writing. You might record a discussion in the medical records. That's reasonable, so it's clear that there has been discussion taking place. That goes for all these complicated discussions around outcome, and it wouldn't necessarily require a letter to the general practitioner, but you certainly would update the GP, obviously, about complications and things that have developed as a result of a treatment that's happened in secondary care. Ed, did you have any other quick ones that you could highlight?
I suppose the very quick one is there a time frame? And I think the time frame really will depend on the individual case, but it's pretty much as soon as practicable, but not too early if you don't know what you're going to be saying.
Yeah, absolutely. Well, in which case, I think it's just by my wall clock here, just gone past 8 o'clock, and I can only thank you all once again for tuning in on a rather cold and in parts of the country very windy evening here, and I hope you've enjoyed the session. I'm particularly grateful to Ed and Jared for fielding the sort of questions so expertly, And we look forward to seeing you at one of our future webinars, so please keep an eye on the website. And indeed, do please use the website, because there's a lot of educational material there that hopefully you will find helpful. So thank you once again, and good night.